And welcome back from lunch, everybody, to the first of our afternoon panels. This is our panel on law enforcement accountability. I'm Mike Lindhorst. I'm a fellow at the Media Freedom and Information Access Clinic at Yale. And I have the pleasure of introducing the moderator for this panel, Jonathan Maness, an attorney at the MacArthur Justice Center's Illinois office, and a member of the teaching faculty at Northwestern Pritzker School of Law, where he co-directs a practicum focused on media law and government transparency. His litigation and advocacy work focuses on government accountability and civil rights violations that flow from government surveillance, police technologies, and national security policies. So before I turn it over to Jonathan, just a note to everybody in the audience, we will leave time for Q&A near the end of the panel. Please put any questions you have in the Q&A box at the bottom of your screen, and then we'll post them to the panelists. So go ahead, Jonathan.
Great, thanks so much, Mike. And I want to also thank Dave, Schwartz, Heather Branch, everyone at the ISP and Abrams Institute for hosting all of us and making the space for us to have this conversation today. So really appreciate it. So our panel is going to focus on the right to protest and law enforcement's response to protesters. I'm hoping that we're going to be able to touch on questions about interference with and abuse of protesters, surveillance of protesters, and protest movements more broadly, as well as sort of legislative and other legal action that is targeting the right to protest. This strikes me as, just to sort of set the stage a little bit, but this strikes me as an important time to be having this conversation. We've seen a resurgence in recent years of people taking to the streets to make their voices heard. We've also seen some troubling law enforcement responses to protests. So, I don't have to remind everyone in this audience, but just to set the stage, I mean, if you think back to 2016, the Trump administration kicked off with the Women's March. There were soon after, there were the airport protests following the Muslim ban. Of course, I guess 2 summers ago now, the murder of George Floyd in Minneapolis sparked a nationwide protest movement that I think is larger than anything we've seen in this country, certainly in my memory, probably since the Civil Rights Movement. And then, of course, there were right-wing protests following the November presidential election, which in some ways culminated in the attack in the Capitol on January 6th. The last 10 months have been relatively quiet, but it strikes me that there's likely to be more protests in the future, given that our politics are so fractious, that it seems like our government is having difficulty responding to sort of the preferences of popular majorities. And given that 10 months after the election, there's still a sustained campaign to undermine the faith in the election. It seems likely that political demands are going to spill out into the streets. Again, and it's worth thinking about, I think, what the legal status of our rights are and what we might be doing to think about it. So in light of that goal, I want to introduce our panelists. We're really lucky to have 4 amazing panelists here. I'll introduce them briefly and then we'll get into the conversation. So Professor Tabatha El-Haj is a professor at Drexel University's Thomas R. Kline School of Law. She is one of the leading experts in the country on the First Amendment right of peaceable assembly. Particularly relevant here, she's been developing or maybe reviving an understanding of the First Amendment that includes robust protection for the right of people to take to the streets in protest. Nora Benavidez is Senior Counsel and Director of Digital Justice and Civil Rights at Free Press. She leads Free Press's efforts to protect against digital threats to democracy. She was previously the director of PEN America's U.S. Freedom of Expression program. While there, she was the author of a comprehensive study of the rise of anti-protest legislation. And she's a leading voice advocating for the protection of protester rights and more broadly issues at the intersection of law, tech, and democracy. Vanessa Del Valle is a colleague of mine and an assistant clinical professor of law at Northwestern, Pritzker School of Law. She's been doing path-breaking civil rights litigation for years on behalf of victims of police misconduct and incarcerated people. Among many other cases, she's counsel in litigation challenging the abuse of protesters in Chicago, and is deeply involved in the ongoing consent decree process in Chicago that aspires to transform many aspects of policing in the city. And finally, Adam Schwartz is a senior staff attorney at the Electronic Frontier Foundation. His work focuses on surveillance and censorship, working both in courts and legislatures to protect privacy and First Amendment rights. Among other things, he's counsel in some really fascinating litigation I hope we can talk about, challenging video surveillance of protesters in San Francisco during the Floyd protests in 2020. So I'm very excited to have everyone together here. Each one of our panelists has been working on these issues from different directions. I actually don't think many of our panelists have had a chance to speak with each other in the past very frequently or to be in conversations. So with that in mind, I'm hoping to make this as conversational as possible, have people respond to each other and build on each other's points. So, and of course, we'll be taking questions at the end. So without further ado, I'd love to dive into our first topic. And I want to start by focusing on what protesters have faced on the ground, confronted with law enforcement and the legal claims that are being raised on their behalf. So I thought I might start with you, Vanessa, given that you've been spearheading litigation in Chicago on behalf of protesters. Perhaps you could tell us a little bit about what your clients experienced and the claims that they're bringing against the city and the police in court.
Yeah, sure. Thanks, Jonathan. So here in Chicago, a team of civil rights attorneys and organizers have been working together to address the police violence that occurred in the summer of 22, sparked by George Floyd's murder. And we have a multi-pronged strategy that we've been working on, which includes litigation, policy work, and public education. So focusing specifically on the litigation aspect. So when all of the protests were occurring throughout the summer, and we had them constantly, every weekend, hundreds and hundreds of people would gather in different parts of the city, all throughout the city, from downtown, north side, west side, south side, people of all ages, all races, all gender identities, all coming together. It was a really powerful and beautiful, beautiful moment in the city. But officers were responding with brutal force to these individuals. We saw consistently at various protests that officers were using batons to strike people in the head, which could be fatal. We saw many of our clients get seriously injured because of these blows to the head, suffer serious concussions, serious big gashes that required serious medical attention. We saw officers punch people with batons and with their fists. One of our clients was punched in the mouth so hard that her teeth got knocked out, and that was captured on video. We saw police use pepper spray and chemical agents indiscriminately on crowds. So even people who were just standing there were sprayed with pepper spray. Their skin was on fire, couldn't breathe, coughing during a global pandemic when people are wearing masks, like coughing because they can't catch their breath, and having officers essentially throw their masks away, and officers who aren't wearing masks and like laugh at the protesters. We saw officers falsely arrest a lot of our clients, and for very, very minor falsely arrest. So they didn't really commit any crimes, but they claimed that they were violating some misdemeanors and some criminal and some city ordinances. And we saw, as a result, our clients spent over a prolonged time in detention, including overnight in many instances. And then some of our clients were also then falsely charged with charges that they then had to go defend in court before those charges were ultimately dismissed. We also saw a number of officers destroy people's properties. There are a lot of protesters brought bikes to the protest, and officers are seen throwing bikes away, damaging bikes, throwing them into trees, taking bikes without giving them back, destroying other types of property such as cameras, phones, glasses, A lot of protesters had, these people wear glasses, their glasses fall when they are kind of in big groups, officers stepping on their glasses so that they intentionally break them. So we saw a lot of that violence going on. So what we did was we had kind of a system that was really organized by Black Lives Matter Chicago, where we can kind of filter all this information through intakes. So people who were abused throughout these various protests throughout the summer were calling our offices. We were doing intakes, hearing their stories, taking down kind of what they were saying and figuring out if they had viable claims. And this all kind of culminated then in us bringing litigation on behalf of 60 individual people who protested from May through August in Chicago 2020 and in different protests throughout the city. But we brought them all together in one case. And we brought claims such as Fourth Amendment excessive force claims. We brought First Amendment retaliatory use of force claims. We brought false arrests, malicious prosecution, conspiracy claims. We brought an equal protection claim, a racially motivated conspiracy claim. A number of people were also denied medical attention. So we brought a failure to provide medical attention, and people were really targeted too. So we had a number of claims, all in this massive complaint. And also importantly, another one of our claims was a Monell policy and practice claim. So in this complaint, we detailed the history, the long history of the Chicago Police Department's use of violence against protesters for decades. Like we went back to 1877 and then took it throughout history and pointed out at various points from 1877 to the present, where officers have used violence to quell protests and to stop people who had progressive views from exercising their First Amendment rights. So this complaint is super massive. After we filed it, we of course started to hear again more people coming forward and asking that they could be a part of the litigation. So then subsequently, we then filed 8 individual cases on behalf of individuals at these same protests. So we represent right now currently 68 protesters in active litigation. I don't know, Jonathan, if you want me to talk more about kind of the where we are with the litigation.
That's maybe we can get to that in a bit, but that's a really wonderful scene setter. I think you've really vividly described what your clients and others face in Chicago. Just to get some more issues on the table, I wonder, Adam, if you might tell us a little bit. I mean, you focused on protests and surveillance of protesters. I wonder if you might tell us a little bit of what you've seen in terms of governmental surveillance of protests or protest movements, what you found, and the work that you've done in that space.
Yeah, thank you for bringing me in. It's a real honor to be on this panel with Vanessa and Nora and Tabatha. There are many dimensions of the state crushing dissent and undermining the movement for Black lives. And I think the most obvious and probably most important and direct way is what Vanessa has just spoken of, which is police literally stopping protest in the streets and punishing it and using excessive force, et cetera. An additional dimension, which I think is woven into the story, is technology. Technology both used by the state to conduct surveillance of protesters and thus to chill and deter protesters, but also technology in the hands of the protesters to fight back. I thought it was significant in Vanessa's description of what occurred that the police excessive force was caught on video. Now, maybe some of that was from body-worn cameras, but I assume a lot of that is from protesters themselves and bystanders. And it's not just the power of protesters to use their phones to record police. It's also encryption on our phones that protects people from police surveillance of their communications. And it's also the internet, which empowers people to get these videos out and disseminated. Looking at the glass half empty side of technology, unfortunately, police are massively surveilling protesters both with technologies that are visible at the days of the protest and with other technologies that might not be visible. So on the day of the protests, people will see officers wearing body-worn cameras, which are capturing the faces and the words and the signage of the protesters. They're flying drones overhead, sometimes manned airplanes and helicopters overhead, capturing the images of the protesters. They're using license plate readers to identify people who are driving to the protests. And of course, there are many less visible things going on. Once they capture images of protesters' faces, whether from body-worn cameras or from the drones, they apply face surveillance to identify protesters. Sometimes they pay shady corporations like Clearview to help them identify Black Lives Matter protesters. They're engaged in monitoring of people's social media, often by establishing phony accounts that they use to infiltrate the movement. They're using cell site simulators, often called stingrays, in order to sometimes identify all of the people who were present in that area. So when we talk about technology and dissent, it's really the best of times and the worst of times. The protesters are using technologies to great good. The police are using technology to great harm. And it's important for policy makers and the legal community to try to advance the former and stop the latter.
Thanks, Adam. I wonder if I might turn to you, Tabatha. We heard from Vanessa about her litigation, which featured a number of claims: Fourth Amendment claims, First Amendment retaliation claims. The theory being that the police were retaliating against disfavored speech. But interestingly, it doesn't seem like there's been very much litigation asserting sort of a standalone First Amendment right to protest, to actually engage in like the conduct of protest. I wonder if you might offer some of your thoughts on that question, whether it makes sense to conceive of the First Amendment that way.
Great, thanks so much. And I hope my internet is stable. And if it is not, I will move to a different location. But I also really am appreciative of being on this panel, and I'm happy to talk about the First Amendment claim. I did want to just react quickly to a couple of things that were said so far. One is just to put this in a little historical context. So when Vanessa says, that one part of the claim is the history of police policy in Chicago of overreacting and acting violently to suppress protests, I actually think there's really good evidence that most assemblies descend into riots and violence when the police show up, and that's been true for a long time. And so I think that's probably not just Chicago, but an important part of the story. And it's heightened, I think, when the protests are protests of police behavior itself, which does sort of trigger that extreme policing that's just vindictive almost. If you read, I read the records in Columbus, and they're pretty similar to what you're describing in Chicago. And then I want to say, I rarely say anything nice about technology, but on the glass half empty, I just want to say the glass has been half empty on surveilling Black civil rights activists like for a very long time before we got all of our current cell phones and our current technology. And I think it's important to acknowledge that as a member of the National Lawyers Guild. And you can see the old civil rights activists sort of still mad about the surveillance that happened from the 1960s. So there's sort of a bigger picture here. But I think one of the privileges of being an ivory tower academic is, instead of trying to win a particular case, like I'm focused on sort of the big picture. And I do think it's been really surprising to me well, it hasn't been surprising, but I think it should be surprising to people that the state of the First Amendment with respect to the right of assembly is so bad that litigators who are making strategic decisions are really right not to make a straight up First Amendment challenge based on the right of peaceable assembly. And, during Occupy, litigators did try to bring some straight up First Amendment claims that they mostly lost. And to the degree they had any success, they actually did have success on some Fourth Amendment claims, although in that case it was, I think, seizure of property. So I'm hoping you guys can hear me. I can't tell if Jonathan's freezing on his end or my end. Okay, good. So, I think that a lot of the problem with the policing is also the uncertainty about what are the contours of the right. So when the First Amendment says it protects a right of peaceable assembly, what does it mean by that? And we haven't really had case law that delineates what the contours of the line between peaceable and unpeaceable are, because of the way that the court turns everything into just a free expression claim or a free speech claim. So one of the things that I really am hoping, one of the reasons I agreed to be here is with a whole bunch of litigators, hoping that I can persuade you all to make some claims that are going to lose for a while. But I hope we'll win eventually, which is to remind the courts and that the First Amendment protects assembly independently of speech, and it protects assembly as conduct. And it says that the right extends to all assemblies that are peaceable. And I think the clear implication is that the opposite of peaceful is violent. And too often, and so what we don't have, to put it very simply, I think what we need to be working towards is a court doctrine that holds First Amendment protections for assembly to the same standards as for speech. So the Brandenburg standard says that speech is protected as long as it does not have an imminent risk of leading to violence. And I think violence to persons and property really is the line. And it's much actually clearer with the right of assembly, because as I'm sure a lot of you are aware, the framers of the First Amendment actually had pretty weak ideas about what the freedom of speech would protect. They were perfectly willing to sort of allow for regulation of blasphemy and a whole bunch of things sedition, a whole bunch of things that we think are protected by the First Amendment, but they had really robust ideas about the right of assembly, having undertaken a revolution. And so that's really, like, I have lots of ideas about how this argument can be made. I think they're textual. It starts with the text. I think there's a really good history to support this read, that at the time that it was adopted, the peaceable was not meant to preclude like illegal nonviolent activity. That's sort of what I think the line should be going for. The First Amendment protects the illegal nonviolent actions of people who are out on the street, because that is still peaceful. That the violence should really be about persons to property. Then of course there are going to be a whole range of issues about, like, well, how many people have to be violent, and how violent does it have to be? Is throwing water bottles violent? Probably it is, but how many people have to be throwing it before you can disperse the whole crowd? But I think that's one of the things that I'm really interested in is I would like us to remember that the problem is much, much bigger than the excessive force, because in fact, police officers routinely charge people for disorderly conduct and other misdemeanors at these assemblies, including unlawful assembly and riot, in contexts where they're pretty sure that there's not going to, that that they're not going to prosecute, and that they wouldn't win if they did. And so that's a huge chilling effect. And part of that is fueled by the fact that we just don't have a lot of clear case law on this line between what is protected and what isn't. And of course, their behavior fuels that lack of clarity, because if these issues don't come to trial, then the courts don't have an opportunity to make statements about what the line is.
Thanks so much, Tabatha. I think you sort of pointed us in the direction of looking at the sort of legal landscape that governs protest, the laws that police are enforcing when they're arresting protesters. And Nora, I wonder if you, if you want to react to anything that's been said so far, please feel free. I know that you spent a lot of time thinking about the sort of legal and legislative landscape governing protests. And maybe you can tell us what you're seeing on that front and developments in legislation restricting protests.
Sure. Thank you so much, Jonathan. I have to say, this is one of the most just exciting panels to be on, hearing these experts. I work on these issues every day, but not each of the facets that you all do. So I'm sitting here just soaking it up. And Vanessa, I started my career litigating Section 1983 cases representing protesters. So I just feel a little nostalgic. I'm like, oh, now on the policy side, and thinking Adam about the various surveillance elements that we at Free Press work on, and which I have not yet delved into very much. So I'm just, I feel really excited and honored to be here. And of course, have worked with Yale and the Media Freedom Clinic for some time. So they hold a special place in my heart, I just have to say. I really want to get into discussion. So I'll try to keep my comments, like my opening comments, rather brief. I'm excited to debate and just sort of like hear what comes out of this, but I'll present for you guys some of what I have found over the last several years around the anti-protest legislative movement that I've been monitoring and researching. It really did grow out of my own personal background as a civil rights and constitutional litigator, having seen in the South where I worked, in the 11th Circuit, just horrible attacks on protesters. And just everything, Vanessa, you outlined, the reality we're facing, the way journalists are also increasingly attacked for even trying to cover these issues. And I'm a First Amendment lawyer by training, and I somehow felt like I was beginning to see, and my colleagues and I, when I was at Penn America, really began observing what felt like potentially viewpoint discriminatory laws getting introduced. But I couldn't prove it, so I started researching what really was happening. And to give you a snapshot, starting in 2017, state legislatures began introducing dozens and dozens of proposals that would do similarly to what the civil rights era saw, of increasing penalties for, public nuisance or other low-level misdemeanor crimes, such as obstructing traffic, highway obstruction, any number of very low-level things that are already existing misdemeanors in every single state. And when I was threading that needle of trying to really research, like, what was happening, why are there, across almost every state around the country from 2017 through 2021, why are state legislatures introducing proposals to narrow our First Amendment rights? And what I found was a few different things. In 2017, we saw 56 proposals that would somehow narrow acceptable speech. And so, Tabatha, I feel like this is an area where we could really jam out together as you were talking about the tests and the limits of this. Things that would normally be given 3 months probation or jail time or low-level fines were suddenly being met with very large fines, $10,000 for highway obstruction. And the state where a bill was introduced, is the same place where a city saw a very large Black Lives Matter demonstration. In the same breath, there were instances 2017, 2016, even 2018 and 19, where there were Native American-led protests that were met with restrictions if you were to do something that was deemed unacceptable or rioting near a critical infrastructure site. That was a very clear, and so I thought it was a very clear example of trying to target the Dakota pipeline protests. What was bubbling up for me, this is still sort of anecdotal, is it felt like there was a very targeted effort to chill Black Lives Matter, racial justice protests, those led by Native Americans against these critical infrastructure sites. And it was really around the time in 2019, I started trying to investigate this more fully. I authored a report that sort of details these legislative threats, but I want to bring us, and you can see that, I'll put it in the chat, it's called Arresting Dissent, analyzing about 116 proposals over 5 years. Donald Trump's presidency and the flip in many state legislatures to Republican helped kind of fan and give them more bravado, Republican legislatures, where they said, let's introduce these bills. They were often copycat bills, so many similar provisions across states. But I want to bring you to 2021, because I think something really interesting has happened and very dangerous that we should be situating in the larger conversation around protest and freedom of assembly. And that is what happened after the George Floyd protests. I mean, Jonathan, you said it very well, and I would just put even a more aggressive point that the George Floyd protests last summer were the longest, largest sustained movement we have ever seen around the world. More days of people every single day coming out to exercise their speech and free expression rights. And we cannot forget that. Our friends ACLID, have done research that I would also point to, the Armed Conflict Location and Event Data Project, which found that 93% of the protests last summer were largely peaceful. And the Washington Post did an article featuring research from Bellingcat last summer as well, highlighting that the majority of violence was by the hands of government and police, not by protesters or journalists. And so to me, I said, well, what does this mean for anti-protest laws? And what I found was that, over 3 years, from 2017 through 2019, we saw 110 anti-protest bills get introduced around the country. In 2020 alone, when there were off seasons for state legislatures, we saw over 100 anti-protest bills get introduced. And what we saw was not just that they were doing things like increasing penalties for highway obstruction, or creating greater fines if someone like me or Adam conducted a legal training for people on their rights. What we were beginning to see is that over the last year, these new anti-protest bills have increased penalties in ways that are kind of reaching beyond just the First Amendment. And so I've authored a second report that really digs into the last year. I call these kitchen sink proposals because they contain at least 3 or more distinct anti-protest provisions. Yes, they criminalize protest activity. They also shield counter-protesters. They strip protesters of public benefits oftentimes. They can even ban people from being eligible to run for public office if they are convicted of one of these crimes. And so it just feels like, what had been a very problematic landscape on these anti-protest bills, and about 22% have become law, it feels like it's now on steroids. And I anticipate that it will continue through 2022. So I just, situate these findings for us to say a couple of big picture things in closing. I think that we can anticipate more of these anti-protest bills. We need to help educate people about what their First Amendment rights are. And we need to really be on the lookout to amplify the legal findings and successful rulings that are challenging these. Because so far what's hard is that a lot of these are not facially unconstitutional. They are going to allow law enforcement to pick and choose the speech that is somehow criminal and thus who they will arrest. And I have every suspicion that it will be Black Lives Matter, racial justice, progressive social movement causes, activists that are most likely either people of color or sounding the alarm on issues around those sort of progressive reform ideas. And when that happens, I just would then point like to Adam's work, to all of the things we kind of already know in this ecosystem. And so I hope we can at some point talk a little bit about the Florida ruling, because there was a recent preliminary injunction ruling in Florida on their kitchen sink bill that has become a law. And part of that bill, now law, has been found to absolutely chill First Amendment rights of protesters, which is a really successful early victory. And I hope we can continue to find opportunities to talk about that with professors, to give us the tools to really challenge what we anticipate will be discriminatory and particularly targeting dissent.
Yeah, so I'd love to pick up on that invitation to continue talking about the courts as a forum to try to vindicate, maybe expand First Amendment rights to protest. I'd also love later in the conversation to talk about other ways of sort of protecting the right to protest through policy or affirmative legislation. But with respect to the courts, so Tabatha sort of presented us with like a really kind of interesting provocation that why is the First Amendment not actually protecting the right to peaceably assemble? That provision of the First Amendment appears to protect conduct, not necessarily speech. And what peaceably means or peaceable means may not be sort of coterminous with like lawful, right? So I wonder, I wonder if folks have reactions or it strikes me that we have a very First Amendment protective court, Supreme Court in some ways, but I wonder if folks have thoughts about the prospect for pushing the First Amendment in this direction, and whether that's likely to be sort of a fruitful way to protect rights in this space, or if we should look elsewhere. I'm curious if anyone wants to respond to that. I don't know. I might ask you, Tabatha, to start. That I'm putting on the spot. Yeah.
So I saw one of the questions in the chat is like, well, what's the loss? Like, if people are winning on the Fourth Amendment, why bother to push this First Amendment bear? And I think one loss is the Fourth Amendment's going to say how police can and cannot disperse. But the Fourth Amendment claims do not say when, right? They don't limit clearly their discretion to disperse protests. And we've seen lots of protests that were dispersed that I think, and for me as a Philadelphian, I think about the dispersal of the protesters on the highway on 676, our local highway, and the police officers are saying the protesters are peaceful. Now, they do get slammed ultimately, and they concede for the fact they used too much force. But the principle that they could disperse these basically peaceful protesters just simply because they were out on the highway, which would be a big deal if it weren't in the middle of a pandemic. I mean, there wasn't really any traffic anyways. It was really sort of, that's, I think, part of what's lost is that sort of, we then get distracted by the level of violence, because that won't always be present on the police's part. A lot of dispersals are more mundane. So I think that's one thing. On the question of what do I think about the prospects for this court? Well, I think, I'm not going to hold my breath exactly for the conservative court to uphold the rights of Black Lives Matter protesters, if framed that way. But, I'm sure a lot of you saw the Supreme Court is suffering a radical decline in public approval. That is going to I don't know if you saw, there's a new poll that says that approval of the justices dropped from about 60% to 49% over the last 3 months. So, you know, Chief Justice Roberts likes to do things to protect the institution. And, you know, I will say in Doe versus McKesson, which some of you will know, that there was ultimately, so that was a case where DeRay McKesson was being sued, not as a civil liability claim against him, arguing that he should owe damages because he should have known that leading a crowd into the streets would create violence, and therefore it was foreseeable that the police officer who was injured by some unknown third party would have been injured. And frankly, it's a little bit unclear whether it's any protest activist or organizer who breaks the rules by allowing a protest to happen in the street should know, or whether it's just a Black Lives Matter protester, a radical left, maybe even radical right. It's foreseeable. I mean, that would be viewpoint discrimination, but it's a little ambiguous in the opinion what they're driving at. But there is a dissent. And I can't remember now if it's a Fifth Circuit dissent or a 10th Circuit dissent, but Judge Willett eventually switches his views, and he writes actually a very powerful dissent in favor of the idea that I've argued for a long time, that that the First Amendment sort of recognizes this need to allow public assemblies some leeway, some breathing room for disorder, and that's critically important. Now, he does try and thread the line that there's a distinction between free speech and conduct, because that is the way that NAACP versus Claiborne is structured, Claiborne hardware. But I actually wonder if the textualists in the Supreme Court could be persuaded to recognize that that speech conduct distinction in the context of a public assembly is a mistake, that is not actually the right distinction in the First Amendment when you're dealing with an actual assembly, and that if you have a group assembling as for political or social purposes, for things that are quintessentially part of the public discourse, right, that there should be that should not be the line. And so I think these are hard arguments to make, but I think they're important arguments to make. And I think one thing I want to react to about what Nora said is, I think one reason I think they're important to make is I think nobody is really focused on them on either the left or the right. So even among progressives, I think there's just sort of a like nonchalance. It's not a big deal. We have our free speech rights. But actually, I think these free assembly rights are really important. And so, for instance, what we don't see, we have a lot of liberal, solidly blue cities and states, but none of them are passing legislation to clearly protect protesters. I mean, there's been a little bit of like, you can't use chemical weapons against us, but there hasn't been the counter, like, no, you cannot charge a protester for breaking like basic traffic rules or obstructing traffic if they're engaged in First Amendment. We haven't seen activists pushing that kind of right legislatively, which might in the end be more effective than any litigation strategy either. And so I think that just tells me there's just a broad nonchalance about this right, which I think fuels the anti-protest legislation, Nora, that you've spoken about on the right. And it means that people are not thinking about this as a moment to seal in some statutory protections for the right of peaceable assembly.
Vanessa, I see you nodding. I wonder if you have any reactions. I mean, you're one of the lawyers who are bringing these cases and not bringing the peaceable assembly claim. I wonder. I wonder if you can react to what Tabatha and Nora are saying.
Yeah. So we are bringing these claims. We're just not getting to the point where we're fully litigating them. So, we're commingling in our First Amendment claim. It is freedom of assembly, freedom of speech, and also retaliatory use of force. So it's all together. And I'll say, I'm actually am working on another protester case where I represent a water protector who participated in the Dakota Access Pipeline protest back in 2017. And he was one of the ones that got very seriously injured. He was shot in the eye with a beanbag pellet and basically got serious injury to his eye. We brought that case in North Dakota District Court, the same type of First Amendment claim. And we actually lost in the district court. So to Tabatha's point, they're really hard claims to prove. And so right now that's on appeal right now in the Eighth Circuit. So and on our appeal, we really did focus on the right to assembly and the right to speech. And in addition to the retaliatory use of force, but we really did want to put front and center that his core First Amendment right. And I'm hopeful that we'll win that. So Tabatha, be on the lookout for that Eighth Circuit decision, because hopefully that's going to be a promising one. So we'll see. So we are bringing these claims, but at least for the massive litigation from Chicago for our protesters in support of Black Lives case, because we just saw everyone experience excessive force. It's easier, right? It's easier to prove. So that's really where we're going to be focusing on is that retaliatory use of force claim, First Amendment claim. And our case is likely going to settle. The point of bringing our case was not to fully litigate it to the end. It was a strategic decision, an organizing decision to put pressure on the city, to bring awareness to what was happening this summer, to counter the narrative that was in the news of what the police officers were saying, that everyone was violent and people were throwing water bottles and firecrackers and using umbrellas to poke officers like that. And so as a result, the officers needed to use all this force. So the point of our litigation was really to counter that narrative and to put the truth out there. As to what Nora was saying, the majority of protesters were nonviolent, they were peaceful. So our litigation is part of that organizing strategy.
Jonathan, can I jump in?
Please go for it.
Okay. I am not hopeful about any Supreme Court affirmation of our First Amendment rights when it comes to assembly. They are so, what we have seen largely is they're so laced with sort of partisan views. If you remember the sort of anti-lockdown protest, you remember these in Michigan, Trump supporters and kind of, I think, far right militia style group, stormed the Michigan state capitol with guns. And at the time, nothing happened to them. But we have a narrative, and I'm sort of in the spokesperson-y role now, not litigating, but I'm we're in a moment where the narrative is very much slanted, and that if you're of a certain movement, you are either more or less violent. And so I just have no hope, frankly, from a SCOTUS perspective. We've also seen legislators, I won't get into all of the legislative issues again, but we've seen courts recognize that bills that become law are actually unconstitutional. And what happens is legislators, like in South Dakota, then they go back and try to get another bite at the apple by introducing an even more complex sort of, less facially unconstitutional law. So we're seeing just legislators chomping at the bit to be able to criminalize speech and assembly. And I say both very consciously. So what I do think when we are talking about enforcement, that's really what we're looking at here, and accountability is, I'm very intrigued by the news a couple of weeks ago that DOJ will be using its Title VI authority to investigate law enforcement discrimination. I think that's going to be an avenue that all of us need to be talking about. We're trying at Free Press to engage with DOJ to try to say, how can you use your Title VI authority to investigate things that might otherwise just go unregulated and frankly, unaccounted for. We don't have a smoking gun in every state where every bill has become a law. to say that, yes, law enforcement are using, picking and choosing the protesters that are criminals. We don't have any of that yet. We're waiting. But DOJ can play a role, I think, in trying to ascertain what are the kinds of practices within various police departments that are discriminatory towards different protesters. It ties in, I think, actually to some surveillance questions, Adam, of, how are police using different surveillance tactics in ways that discriminate. So I hope I don't sound too deflated, but I in no way am holding my breath either, Tabatha. And I just think that we have to consider other creative mechanisms when we're talking about these issues. And it will continue to get worse. It really will.
Yeah,
Can
I don't know.
I jump back in?
Oh, sure.
Oh, because I want to say that I totally respect the skepticism about like how it's going to work to push these claims and the real world constraints that litigators have. But I also think that there are some risks of always, like both of you carefully said, speech and assembly altogether conflated. And the risk I see is actually in the way that the riot charges are being litigated after January 6th, and some cases from before January 6th, but I think that's really going to hit like hard when we get these. So as some of you may know, that there have been these First Amendment challenges to the federal anti-riot statute. And most of them take this approach that, well, the statute violates Brandenburg because it criminalizes, say, organizing. One circuit said organizing was not speech, or it criminalizes sort of, I don't know, there are a few words that basically amount to organizing in different ways. And so if you can't prove that your activity to organize this group that turns into a riot, like a full-on riot, was an imminent incitement, right, then it violates the free speech clause under Brandenburg. Whereas I really think that if we were thinking about assembly and speech differently, we would say these are two different things. Like Brandenburg was an assembly, but it was not a real assembly. It was like a movie that was being made, right? And there was no like threat from the assembly. I mean, it was not really an assembly. But if the anti-riot statute, I mean, the one thing that the First Amendment, I think, really doesn't protect is rioting, right? Like that seems pretty clear. And I'm really glad both of you made a point of emphasizing 93% or more of these protests last summer were really peaceful. They were really not riots or unlawful assemblies. Like they were just people expressing their political views in a system that doesn't really listen to everyday Americans that well, let alone Americans of color and their allies. And I think this is sort of a place where it really could matter, because I think that if litigators keep pushing this, there's no difference between thinking about speech and assembly, and litigators on the left, progressive litigators are going to say, oh yeah, we're also worried about this riot statute because look, there's some speech that it's covering and the speech is, doesn't meet the Brandenburg standard. I just think that it's not good for democracy. I mean, we really need to be able to say that there are riots and then there are public assemblies, and that's a very hard line, but I think it will help us if we don't conflate the speech and the assembly pieces, and we really think about the good reasons that Brandenburg was a speech case. So I think that there is more at stake than meets the eye in some of these claims.
Thanks, Tabatha. I wonder if, we've talked quite a bit about the prospects for the First Amendment in court and creative First Amendment lawyering. Adam, I want to bring this back to you and focus on surveillance for a second. Seems like there may be room to think about using other tools, other legal tools to protect the rights of protesters. surveillance transparency or you've worked on surveillance transparency ordinances that are generally meant to create sort of local control of police surveillance in general. But you've managed to find a way to use that kind of local legislation on behalf of the right to protest or to protect protesters. So I wonder if you could tell us a little bit about that, and also just generally if you see ways to get at protester rights that may not depend on an uncertain prospects in court.
Yeah, so I will speak about the litigation we have brought, which, as you say, is not traditional First and Fourth Amendment litigation. I do just want to quickly respond to some of the excellent points of my fellow panelists. Tabatha, one of her secondary points was about the history of surveillance of people of color, and I do want to lift up that point and say, yeah, it goes back at least the 1800s with the lantern laws, where people of color had to literally carry a lantern so their faces could be seen at night, so the state could surveil the movement of people of color and communities. And every decade has had a different technology that police have found to use to surveil people of color. On the other hand, people of color have always used technologies to resist the oppression. My colleague, Alexis Hancock, wrote an article, which I'm going to drop right now in the chat, called Coded Resistance, about efforts by people of color to use communication and other technologies to resist oppression. Another point Tabatha made was about the need for laws to protect protesters. Absolutely. And those laws should include provisions that crack down on police surveillance. Nora's kind of telling of the horror of these anti-protest laws needs to be told and resisted. I would just add that there also are anti-protester use of technology laws. So, for example, laws that criminalize the recording of police, laws that criminalize the use of the internet with vague and overbroad bans on harassment or abuse in internet communications. And Vanessa, I thought, super helpfully centered discriminatory use of surveillance technology. Alvaro Bedoya, who was just nominated by the president to the FTC, kind of has emphasized the color of surveillance, always centering that these technologies are rolled out in minority neighborhoods. They are always used to target minority liberation movements. They always inflame injustices that already exist in our criminal justice system. And so we always have to center racism in the use of surveillance technology. Now, to turn to the actual question, sorry for going off the rails there. One measure that anti-surveillance groups like EFF like to enact across the country is called CCOPS, or Community Control of Police Surveillance Technology. These are laws adopted in 20 cities across the country, from Massachusetts through California, through Tennessee. And they basically say a city agency cannot adopt a surveillance technology without first getting permission from the city council, and the city council can't approve this without there first being a chance for members of the public to engage and resist. And so this is a real opportunity for members of the public to block police from adopting new surveillance technologies, and that has happened with these CCOPS laws. So in the summer of 2020, with the protests against the George Floyd murder across the country, these were happening in San Francisco too, which has a CCOPS law. And the city police got access to a business district's network of 400 surveillance cameras and used it to spy on Black Lives Matter protesters, but they did not get permission from the city council to do so. And so I am so inspired by Vanessa, who brings the direct First and Fourth Amendment claims against these and kind of abuses, and that has to continue. But in addition, we can bring CCOPS litigation, saying that the police behaved unlawfully by getting access to this network without getting the city council's permission. And so we are litigating that claim right now. We're in the midst of summary judgment proceedings. Again, this is an adjunct and not a substitute for traditional First and Fourth and 14th Amendment litigation against police abuse of surveillance technology against protesters.
Yeah, I think that's fascinating piece of litigation, because it's been very difficult for people to get to court on claims challenging surveillance as surveillance. The Supreme Court has made it very difficult to show standing. Decades ago in Laird v. Tatum, the Supreme Court decided that surveillance of people who were opposed to the Vietnam War didn't itself create a sufficient chilling effect to allow them even to get into court to bring a First Amendment challenge. So it's these kinds of creative litigation strategies and thinking about whether there are ways to leverage existing laws or new laws on the book statutes, I think are very interesting, appealing. I wonder, we don't have too much time left, but it occurs to me that a lot of the details, or the right to protest depends a lot on how police exercise their discretion on the ground. And we've been talking about how the First Amendment may offer sort of more constraints on what the police can and can't do. But I think it'd be useful to focus on other sort of other sources of law that regulate how the police exercise their discretion. So, there are police manuals, police guidelines. There's, I'm going to ask Vanessa to talk about this right now, but in many cities there are court orders that, especially bigger cities, are court orders that are in place to oversee the police. So, I wonder if, Vanessa, you might tell us a little bit about the consent decree process in Chicago and how that may be a means to protect First Amendment rights on the ground. And then I'd invite other folks to talk about similar sort of non-litigation policy efforts to protect the right to protest. Yeah.
Yeah, happy to. So the Chicago Police Department is under what is really considered a historic consent decree, because it wasn't, I'm not going to go too much into the details about how we got it, but essentially it wasn't the result of the DOJ implementing this consent decree. It was the result of years of community organizers pushing for this. And also one thing that makes this consent decree really unique is the community groups that I represent, Coalition of Black and Brown organizations throughout the city, have enforcement power of this consent decree. So through the enforcement power, we've been able to get in negotiations with the city to change their First Amendment policy, because the consent decree covers provisions such as impartial policing, accountability, and excessive use of force. And so we've been able to tie in the First Amendment activity and say the police response to the First Amendment activity the summer of 2020 really showed how the police department is not following any of the things they were supposed to be following of the provisions of the consent decree. So we were able to tie that in. So through this process, we've been negotiating with the police department changes to their First Amendment policy. We're still in that process, but I can go through some of the specific demands that we've been making that have been relevant to the conversation we've been having. So Tabatha was talking earlier about dispersal orders and how important it is to talk about those and address those. So one of our real primary focuses has been on dispersal orders and basically having officers use dispersal orders as a last resort. What we saw during the summer is they would use dispersal orders right away or claim that they were dispersing the crowd and that people were violating these dispersal orders and that gave them an excuse to arrest people. So our focus has been on when and where officers can actually use a dispersal order and putting really strict guidelines on this. So for instance, before issuing a crowd dispersal order, the field commander on scene, who's the only one that can issue it, the field commander must consider and attempt all available less intrusive measures to stop the conditions necessitating the issuance of the dispersal order. And he or she must document available and attempted less intrusive measures. So there must be a documentation of this before they can verbally issue these orders. And they must allow sufficient time for individuals and the crowd to receive and comply with the order, including using multiple methods of communication to provide effective communication with the crowd, including people with disabilities, people who might not speak English, So ensure that that they don't just issue the dispersal order and then start arresting people right away, giving them people time to comply with the dispersal order that they should be issuing in at the last, after considering all available and less intrusive options. Another thing that we've been really focusing on is their use of arrest. So our demand is that they're not supposed to be arresting people engaged in First Amendment activity at all for minor petty offenses or misdemeanor offenses that do not cause a threat to any person or property. So this should be really limiting the use of arrest. And the same thing with using force. They shouldn't be using, this is obvious, they shouldn't be using force in retaliation for someone exercising First Amendment activity, but you'd be surprised that that wasn't really explicit in CPD's First Amendment policy. So we want to make that very explicit. And then also having provisions on when officers can use chemical agents and that they can't use our demand is that they can't use chemical agents on crowds, period. Because there's always going to be people in crowds who are peaceful, are going to then feel the effects of that pepper spray. And then lastly, I'll say another really big part of what we've been focusing on is on accountability. Because you can make all these changes to policy and even to law, but if officers on the ground are actually not being held accountable for their actions, and they're just going to continue to do them despite all the training on the changes of policy. And so what we really are trying to see is that any officer who's accused of engaging in unlawful conduct is stripped of their police powers. There's a whole process in Chicago of how officers are investigated and through the FOP contract of what process they need to go through before an officer can actually get fired, and that takes years. So in the meantime, officers are continuing to do their jobs, even though they've been accused of violating people's rights. So what we're really requesting is that officers are held accountable and they're stripped of their police powers right away. And so that we can see, people can see that they can't really just violate people's rights with impunity.
That's really fascinating. I'm glad you brought us down into the sort of granular level of regulating the behavior of police at protests. I wonder if other folks have reactions to anything Vanessa said or thoughts about other ways to secure the right to protest that doesn't rely on sort of reactive litigation.
Yeah, I'll jump in briefly. Vanessa, this was so interesting hearing about the sort of like trying to create the carve-outs on dispersal orders. I find education and protester, even journalist education and awareness of these issues is very low. And in practice, the very things you were saying so rarely happen. Police are just not doing those things, giving people alternate avenues and the ways of communication. So in practice, and we can't forget in practice what it's like to be at a protest, like those things are so important to just sit with for a second. We can talk however much in an ivory tower way and in our researcher expertise lane, but it just, if you've been at a protest, you know what that feeling is like, and the feelings of terror with police not complying with what they should. I will briefly talk about some other efforts to introduce and pass restrictions on the use of less lethal weapons, tear gas and rubber bullets for crowd control. I am not the go-to expert on this. I would absolutely recommend my colleagues at the International Center for Not-for-Profit Law. We work very closely together. They have a US protest tracker, which tracks some of the laws that I analyze and are monitoring and what we're talking about from a litigation perspective. But these are policy efforts to kind of get to what you're asking, Jonathan, like what else can we be doing? And the truth is, like, let's be real. The First Amendment exists, and oftentimes I talk with members of Congress who say, what can we do other than introduce a resolution that is literally the text of the First Amendment to remind people that freedom of assembly exists? Like, what else can we do? And it's a very flippant question, but I get where they're coming from. It's really hard to figure out what accountability looks like when we just see time and again these violations. So California just signed into law yesterday a new law which is going to put restrictions on the use of less lethal weapons. there are going to be other, I'm going to put in the chat this link. There are other provisions here. They're trying to create a system to investigate and revoke or suspend peace officer certification for serious misconduct. There are going to be transparency measures over misconduct records, which I think is really important. I would love to see a national database of these misconduct records across all police departments. I'm not sure how realistic that is. But states across the country are starting to look at enacting laws that would limit the use of certain weapons in crowd contexts. So Massachusetts, Oregon, Washington, Colorado, Virginia, Nevada, these are all states that are looking at and enacting various laws. So I guess I'm not, thinking this is going to be the silver bullet that helps solve the issues we are all talking about, but it is one avenue of accountability. I'll put some things in the chat.
Thanks, Nora. Any other thoughts on that point? I'd love to get to the question we got from the audience before we run out of time. But any other reactions on that set of issues about legislative or non-litigation strategies?
I'll be very quick because I know you have questions in the audience, but what I will say is in the 19th century when people had a much broader conception of the right of assembly, their criminal statutes were much clearer about the definitions of riot and unlawful assembly. So some states today are clear and they limit a riot and unlawful assembly to violent action to persons and properties, but other states like Pennsylvania are very vague on unlawful assembly. I think Vanessa's point, of course, is right. Like you can have all the laws on the books, and then there's still the question of what police do on the ground and how you hold them accountable. But if you don't even have the laws on the books, then you're bargaining in the shadow of law that is not helping you at all. And so I really think at the very simplest level, local municipalities could pass ordinances that made very clear that a violation of a time, place, and manner restriction was not the basis for a dispersal or for a criminal sanction, maybe nominal fines if you assemble without a permit, maybe, but they could make that clear. They could make clear that like disorderly conduct as a statutory matter, here's the frame, but it cannot be used in a First Amendment context. I think actually courts and the people understand what count as a First Amendment context. We didn't really people didn't say that the Black Lives Matter protesters didn't have a First Amendment right to assemble. They fought over like whether they had breached it. But I think there's some consensus about being out on the street is a right. And then there's a lot of fight about what you can do when you're out there. And if the statute's just made a little bit clearer that certain kinds of low-level misdemeanors were off the table. Now I understand like the District of Columbia, your colleagues at the not-for-profit, the International Not-for-Profit, I can never say the whole name of that organization, but I really like them. They tried to push DC to do that. And DC was very, like the police officers were very reluctant to change their statute that way. But that tells us something. That tells us that they're counting on that discretion and that should be an avenue for reform. But I think, Vanessa, all of the things that you laid out about the police internal manuals seems like a really important, a big step beyond what some of these cases have said.
Thanks, Tabatha. I wanted to, we only have a few minutes, but I just thought I'd pose the question we got from the audience, which sort of brings us back to some of the discussion earlier in the day about transparency and FOIA. And the question is about the tension between transparency of things like body cam footage and chilling effects. And the concern is that footage that identifies individual protesters could lead protesters to be subjected to retaliation from employers or being targeted by political opponents. I think we've seen these kinds of concerns expressed on both the right and the left. A lot of people who participated in the January 6th riot attack on the Capitol are very upset that their identities were disclosed, and likewise for people who participated in racial justice protests. So I wonder if folks have thoughts about that tension, about transparency around identities of protesters.
So there is an explosion in the amount of video recording of things happening in public places at protests and otherwise. And this has good and bad sides. It can be good by promoting transparency and truth-telling about wrongdoing. And it's bad because it invades people's privacy, and it can chill and deter. And so we have to take a kind of nuanced, careful approach to this. We absolutely support a right of individuals to record what is happening at newsworthy events in public, including at protests. But we do suggest that people at protests might want to observe the privacy and security of fellow protesters, and to the extent they reasonably can, avoid catching other protesters' faces, because that is information that might be used against them later. When it comes to police using cameras, we absolutely do not want them aiming cameras at protests. That's been a Chicago consent decree, Red Squad back in the 70s. There was a specific ban on police aiming cameras at protesters unless crime was actually occurring. We are skeptics of body-worn cameras for police. We oppose them unless there are strict safeguards regarding public access to the information and officers not being able to review footage, et cetera, et cetera. But body-worn cameras are highly problematic, especially for a right to dissent. There's so much footage on the internet of protesters who've recorded protests and then posted on their social media, which is one of the reasons we think police should not be looking at social media absent individualized suspicion of crime, and definitely should not be doing phony social media accounts to see that footage without a warrant from a judge based on probable cause. So there is a real tension about privacy versus transparency with all the video footage of protesters, and I think we can adopt some safeguards and cultural norms that try to get the good without the bad.
Thanks, Adam. Does anyone else want to react to that? So I think we are running right up against time. Unfortunately, I think that's the end of the conversation. I really want to thank everybody in this panel. We covered an enormous amount of territory, everything from the scope of the First Amendment to the details of police department policies and everything in between. So I hope this has been useful for everybody listening. Ideas here that you can take into your own practice or your own work. And thank you for giving us the opportunity thank you to the ISP for giving us the opportunity to have this conversation.
And I just wanted to thank all of you for that great discussion. I think this has been really interesting. So thanks so much for joining us for this. And everybody, we're going to take a quick break. We'll be back at 2:30 for the next panel on national security accountability. So we'll see you then.